Welcome, everybody. Thank you for joining us today. Perry McLennan here with Chris Gant Sorensen, as always. Thanks for joining us again for another employment law update. It seems that we're focusing on COVID for all of these, and we haven't had one in a few weeks now. So we're both excited to speak with you again today for a little while. We've been, as I said, primarily focusing on COVID-19. That still seems to dominate a lot of the client questions that we get. We've mixed in a few things today, as we did last time, that are kind of non-COVID related or tangentially related to COVID, just to mix things up, because I'm sure that some of you are tired of hearing and talking about COVID. And hopefully by the fall, we're going to be doing employment presentations on something other than COVID, but we'll just have to see how that works out. A couple of reminders about today's presentation. Everyone should have access to the Q&A box, and we are happy to try and answer questions throughout the presentation through the Q&A box. While I'm speaking, Chris can monitor those questions, and while Chris is speaking, I can monitor those questions. We may answer some of them out loud so that other people can hear them, or so that we can provide a little bit more of an answer than just in the text box. But just a reminder about that. The presentation slides and recording will be shared after the event, along with our contact information. If you have any questions about that, about the presentation or anything with respect to employment law. And then a reminder also about our COVID-19 resources page, which you can find on the home page of our law firm website. That has a lot of information, not just related to employment law, but related to, some other areas like insurance and corporate law and things like that. scemployersblog.com will include a link to that at the very last slide, but just a reminder that if you're not signed up for our blog, we're still trying to keep everyone updated on material developments through that blog as well. All right, so just an overview of what we're going to talk about today, as well as kind of where things stand right now. I hope that everyone's lives in the human resources field has calmed down a little bit. Fortunately, we're not seeing as much, legislation and changes and things like that as we saw in the spring. So hopefully everyone's had time to kind of fully grasp the FFCRA and the Paycheck Protection Program and all the kind of new rules and regulations, or at least know that they exist and know to ask questions about them. But things are still developing. We've had a few interesting wrinkles. One of the primary things that we've been discussing with clients is what to do about employees that are sending their children back to school or keeping their kids at home. So Chris is going to tackle that topic first, because I know many of you may have questions about that. That's front of mind for everybody right now, and was sort of, honestly, kind of an additional wrinkle that the legislators, probably didn't think that we'd be dealing with come August, but here we are. So we're having to try to navigate that. We're about 6 months into this pandemic, and so we're kind of reaching the point where we're actually seeing some litigation trends across the country of lawsuits that are being filed against employers for COVID violations. And so we'll talk a little bit about that. And then just an update on pending legislation and what may happen in the next couple of months. Because there is still potential for some additional laws to be passed on this. We are still seeing, just kind of anecdotally, we are still seeing a lot of questions regarding employee leave. Personally, I've seen a lot of questions about what to do with employees that employers think are abusing the leave, who are out on leave and not communicating with the employer, all those types of things. So I know the FFCRA continues to be a challenge, and we're also at the point now where we're getting questions about what to do with employees who have run out of their FFCRA leave and still may need time off. So although we haven't had any new regulations or laws, we're seeing it sort of morph into different phases here. I've got a couple of notes up there. There's still liability concerns about safety, and really more commonly just routine employment decisions like termination of employees. I've had a lot of clients call me about what would normally be routine termination decisions that have been complicated by the fact that this employee previously took leave for COVID and previously tested positive. And even though their termination has nothing to do with that, they're still concerned that the employee is going to blame the termination on COVID. One more thing, and then I'll turn it over to Chris to hop into the school issue. We're really seeing now kind of a clear picture that COVID-19 is really accelerating some trends in the workplace that have really been developing over a couple of years. Chris and I were on the Survive HR podcast recording yesterday, which if you're not listening to, it is an awesome resource. Chris and I jump on there from time to time to talk about employment law stuff. We were on there talking about remote work yesterday, and we worked with a lot of clients on remote work policies pre-COVID, but we're both getting a lot of requests from clients to work out remote work arrangements, either just during the time of COVID or even long term. And increasingly, we're seeing employees request that either as a benefit or in the recruiting stage or whatever the case may be. So I think that's going to look a lot different in the coming months and years. Increased demands on working parents. I think they talked about this on the Survive HR podcast as well. This is one that if you're not dealing with now with the school issue, I think you're going to certainly have employees that either like working from home, like the flexibility and more time it provides them to spend with their kids, things like that. And so that's an important issue to keep an eye on. And then protections for vulnerable workers. Unemployment continues to be high, particularly among those low wage earners. COVID-19 has kind of separated out the white collar management type of workers from those hourly non-exempt workers who are really struggling in this economy. And I think that's important when you think about termination decisions as well. Chris, were you wanting to jump in?
No.
Okay. All right. I'll turn it over to you, Chris.
No, sorry. I was not raising my hand. Perry and I have talked about how we miss getting the opportunity to actually speak to you all in person, and he and I can communicate more freely then, which is our way. We think that's best when the other has information to add in. So I think I might have sent him the mixed signal, but I was unwittingly raising my hand. So I am going to talk to you about the legal aspects that you need to consider in your request, dealing with your request for situations involving your employees and your who have school-age children and who have school concerns, virtual schooling, and the like. But I just wanted to give you some sort of general information and food for thought. CDC issued this report on August 14, and it's indicating they're learning more about how COVID impacts children. And so there have been increases in children having the infections from March to July, and that is only increasing now as the schools are opening back up for the in-person schooling. The rate of CHIP hospitalizations is increasing, and for those who aren't aware, CHIP is a government-provided health insurance program for children who are under 19 and in need of health care due to lack of resources. Of those hospitalized, 1 in 3 are being admitted to the ICU. This is the same statistic as with adults. And I know you're hearing this in the news. I've certainly been hearing it in the news, but CDC has indicated that the viral loads carried by children are more, are stronger, at least the same, and often stronger than that carried by adults, so that they can spread the virus more effectively. You add to that you're dealing with children who are maybe younger, certainly younger than high school age, and a little harder to control, especially elementary age. And I don't know how you're going to be able to keep them separate from other folks. I mean, they're just not, they don't have that proclivity to be able to do that. And so your employees who have children who are school aged have obviously a very real concern. I cannot imagine having a child in school at this time, during this time, and particularly a young child in school. I can't imagine it. Next slide. So the things you should think about, not just the law, broader issues such as the public policy impact. Here's an opportunity for you to establish a connection with your employees, to show them that you can work with them and give them concessions and do what you can do to help them through these times. Think of the loyalty that will build for you with these employees, the employees that saw you do this, and other employees in the future down the line. It is a great recruiting mechanism. It is a way to be commented on all of the websites. It's a very, very understanding and open employer. So this is an opportunity. If there's any way for you to take it, don't miss it, because I'm convinced that sort of conduct now, that sort of empathy and compassion that employers can show, willingness to discuss, openness to communication on these issues, it's only going to benefit the employer more than the employee to whom is getting the concession. That being said, I understand not everybody can do that with their positions. Some positions absolutely just require someone present. There can be things you can consider for those as well, and we're going to talk about some of those, but I would encourage you to think much further out of the box to do what you can do to accommodate during this time. I am starting to see reduced hours requests, and just before we got on to this call, I was involved in advising a company on one of their employees being told by the employee of their spouse, their wife's employer, that she would have to resign because she couldn't come and perform her work. She was a healthcare worker, which suggests to me that she may not have even used her FFCRA leave. Now, if it's not applicable to that company, that's a different story. But here's a situation where outside of liability, it's just a position that's been taken that is maybe not one that's a very popular one. So if there is a way for you not to do it, please think as broadly as you can about how you can work with the employee. So when I say what risks do you take in not accommodating, I'm referring to the non-legal, although there are legal risks, and I'm referring to how you are perceived. Right before all of this came down, we were in a tight labor market, and all of us were considering all kinds of flexible work schedules. That's where we were. That's certainly what Perry and I were talking about when we were out talking about how to deal with, hiring issues. We'll get back to that. So here's an opportunity to maybe go ahead and implement that. And by the way, give yourself this great reputation where people want to just always come work for you. Brittany, next slide. So communicate. Through this whole thing, to me, that has been so important. And a lot of my clients I know are communicating weekly. I think that's great. In this situation, one of the best ideas I ever heard about how to deal with what are you going to do about the school is to actually just ask the employees what they need. Ask them what they need. One employer who is a national employer was concerned, what will this require us to do? Well, we have to revamp everything we do. And the director of HR found that when she just reached out to the employees and asked, number one, is this a problem? Number two, what help do you need from us? It was far less of a problem than they expected. And what the employees needed was far less than what they anticipated. And it was easy for them to grant it. As with any accommodation, I'm going to want you to document it in writing for two reasons. One, you have an agreement with the employee about exactly what the expectations are, so both of you are on the same page of music. And you also have documentation of the accommodation for later to show that you were compassionate and tried to work with them to the extent that any claim or litigation is filed. These are the types of questions I suggest you ask your employees. You don't have to promise that you can grant anything, but ask them, what are your plans? What are your needs? Is there are there any changes you need to your current schedule? Are there any accommodations you need? You maybe don't have to ask about current schedule. You can just say, what do you need from us? You could just say, what are your plans? What do you need from us? I don't think there's anything wrong with asking, what are your plans? The only FFCRA benefit available to employees right now is the EFMLA. And as you recall, any sort of notice of advance necessary leave that's needed does have to be communicated 30 days or more in advance. So I don't think this is an unreasonable request, nor do I think it's an unreasonable request when you're couching it in terms of, we're touching base with you. We understand that it's a stressful time. We understand that those of you with school-age children are concerned about their children and the safety of their children in the workplace, in the school, and also in the home. We want to try to work with you where we can. We can't make any promises, but we ask for you to let us know your plans and what might your needs be. Just a simple little email communication or a survey of that nature would be great. Next slide. So here's some ideas. Of course, teleworking and remote work, and we'll cover that in more detail later. That's a great idea, but that's not available for all. If it is available, though, consider it. I will tell you the Department of Labor actually recommends it in the FFCRA. So if you're an employer that's subject to the FFCRA, this is something you're actually required to consider. It's also recommended by OSHA. Job share. So if we've got a job that has to be performed boots on the ground, then can you do job sharing? Can you do flex schedules? Can you do split shifts? Can you do part-time shifts? What kind of things can you do? You know, if you're more than first shift, can you have somebody work 4 hours in the morning and then come back 4 hours later? Just try to think outside of the box. Some companies have been offering childcare subsidies, or some have tried to offer childcare services or school services on site. If you are a company that wants to do anything on site, I would encourage you to get thorough legal advice before you set this up, just like you would do with any on-site clinic, because there's all kinds of liabilities associated with providing those types of benefits on site. If you're not willing to or not able to invest that type of energy in doing the setup, I just wouldn't recommend it. Instead, if you want to help with some sort of child care assistance, maybe a child care subsidy. You know, the IRS has said that during this time, your employees can change the benefits that they took under the plan. They're allowed to do that. Well, this might be a new benefit that you might be able to offer in lieu of some other benefits that they're selecting. You know, there's all sorts of creative ideas that you can discuss with your broker, but consider maybe offering childcare subsidies in lieu of having anything on site. Analyze, after you've decided what sort of flexibility you can offer, analyze all of your job positions to determine which might be suitable for any type of these concessions, and if you can modify them, you know, in any way to meet any of these ideas or other ideas. Next slide. So let's talk about remote work. I think this is an interesting study that I ran across when we were pulling these slides together. Unum surveyed, I think it was over 1,000 employees, I'm pretty sure 1,100. And they discovered that 3/4 of their employees were actually more productive in performing remote work. That has certainly been the case for me. And I think that's the case for a lot of folks. I was surprised, however, about this statistic, because in the news we were hearing that people weren't productive. But according to Unum's study, 3/4 of their employees were more productive, 1/4 not. So when you're considering teleworking, evaluate if the reason for not having teleworking is simply, no, we need to have people in the office. That's not how it was done. Or if there's some tangible reasons why it's not suitable. If there are tangible reasons that it's not suitable, then it's not suitable, and that's understandable. But if the decision is on the basis of, no, people need to be at work, that's an older notion. That's an outdated notion. And I would say to you that this is an opportunity to come up with a new way to attract more talented workforce. Millennials and the folks coming up behind us are not willing to adhere to conventions of this nature. And so this is a great way to reprogram your workforce and your workplace climate, and I highly recommend it. If you don't, you might be left behind for the businesses that do. Flexible work hours. That was something that Unum looked at. And what they found was they were able to do full-time remote, part-time reduced hours, job share, job split, unpaid leave of absence. So in a situation where you cannot allow an employee to remote work and you cannot change anything about the schedule for their job or whatever changes you're offering don't work for them, then give them an unpaid leave of absence. Most of you already have that in your policy, but no attendance points penalty. Just grant them an unpaid leave of absence. Child care assistance. We talked about that, and so I won't get into that. But that was something else that UNUM was doing, as well as providing screen care providers in the home. Now, if you decided to provide screen care providers in the home, I would encourage you to go through a service that provides that is incorporated, and enter into a written agreement with them that they will indemnify, hold harmless, and defend the employer for any incidents that arise out of any sort of screened care providers in the home. All right, next slide. So let's talk about remote work. If you allow remote work, we recommend you have a written policy and you also have a specific written agreement with your employee that's performing the remote work. You have to state in the policy as well as the agreement that it's temporary due to the unique situations, that the employee will report to the workplace when requested. The employee is going to remain in regular communication with supervisors and coworkers. The employee is going to agree to be at the office space, the designated office space in the employee's home during certain work times and available. You don't want to your employee during work hours to be calling you from the grocery store and the like. And so in this situation, even with your exempts, it's fine to set out that these are the office hours we expect you to be available and in your home workstation. And then you can allow for any sort of breaks. You can also require them to take PTO as they would as if they were at their desk for any time they're going to be away more than the lunch break. And again, I'm talking about exempt employees. For non-exempt employees, you're going to need to make sure that there are ways that you can properly record their time. You're going to require them that they need to get overtime approval before they work it, just like they do at work. And as usual, if they've worked over, then you're going to have to go ahead and pay them. And if they continue to violate the policy, then you'll have to take discipline action. So these are some opportunities for you to write an agreement that's going to meet your expectations, as well as grant the employee the opportunity to remote work. Next slide. If you are providing them with equipment that they're going to be allowed to take home to their office space, something that you need to do is in your agreement with them, list the equipment and the value of the equipment, and include a statement underneath the equipment that you issue that says that the employee agrees failure to return the above referenced equipment will justify a deduction, a payroll deduction in the amount stated above, and that the employee consents to this payroll deduction. I continue to see policies in our state that say employers will deduct for employees' failure to return whatever equipment, but when I ask, do you have a written consent from the employee for this, they don't, many don't. And when I ask if you have consent and they say yes, does it state the exact amount of the value that's going to be deducted? If the answer is no, then you've not complied with South Carolina Payment of Wage Act. You also have to put some criteria around the equipment. Others can't use it. It's got to be stored in a safe place. Do not store it in your car. Do not keep it out where it's visible and can be stolen. Be clear about where you expect this equipment to be stored and how you expect it to be used. And then in regards to non-exempt employees, ask yourself, how are they recording the time? It'll be great if you have a software that's able to do that. And you may say, well, how are we going to keep up with whether they're able to do their work? You've got a couple of different ideas. Some businesses' work lends itself to keeping up with keystrokes, and larger companies certainly have those types of databases where they can figure out how productive. You know, what are the metrics that you judge the employee by? And then how can you modify those metrics to apply to their productivity? Another thing you can do is require them to account for the hours in their day, completing a list of the things that they did. And that can be very telling, especially to employees who are not used to having to be accountable for their hours. That's going to teach you a lot about whether or not you're overstaffed or understaffed, you know, that sort of thing. That's going to be helpful to you as well. Next slide. All right, so employee leave requests, and these are the things that are probably the most problematic, because employees are creative. They're creative always, and the pandemic is no exception. So first of all, and I know you know this, but this is just a refresher, just because someone's uncomfortable to come to work is not going to be a legal excuse unless certain criteria apply. So OSHA imminent danger rule. If someone is saying it's unsafe, I don't want to come to work. For an employee not to be able to come to work due to unsafety, unless they've got some sort of medical condition, and we'll talk about that next. It's got to be a threat of serious physical harm or death, and it's an imminent danger, one that cannot be resolved by them making a safety complaint to OSHA. It's about to occur. It's imminent. So, that's a slide that we have from earlier presentations. I'm glad to send you that information, the slide that has the data directly from OSHA's regulations. But someone having safety concerns at work that are not going to impact them immediately are just them expressing safety concerns that you have to entertain, but it does not mean they cannot come to work. So FFCRA provides paid work leave for certain situations if employees are not able to come to work. And for those of you who have been with us through the pandemic and our webinars, you know that takes more than the hour we have to discuss. We've got a bunch of materials on our blog, and we've got our recorded webinars about the FFCRA rights on the HSB site. You can access all of that, and I would encourage you to do so. But there are two types of leave that are provided for employers who are subject to FFCRA. And so if those apply here, you're going to have to grant. And then just the the old school FMLA and the ADA. So if I am an employee who is high risk and I am not able to come to work and I'm able to document the condition that's high risk, then you have to accommodate me with either job modification or leave like you would if I were on site. So we'll talk about that a little bit more, the things you have to think about. As far as FMLA, if I have a serious health condition or I need to care for a family member who has a serious health condition, then if I meet the other criteria for the traditional FMLA, I need to be granted FMLA. That is unpaid FMLA. It's 12 weeks or intermittent, but all those rules still apply here. And it's just a reminder for us not to forget them because there's so many new COVID laws that it would be easy to forget them. If none of these apply, then I'm going to ask that you document the reason for the request, the statement that they cannot report to work, and the reason that you are denying it. I don't want you to be heavy on the reason, but I want you to state the reason, and that needs to be documented. All right, so please remember this as well. Uncomfortable employees are going to report safety concerns to you. They may be doing it in the context of saying, I'm not comfortable coming to work. But you've got to remember to respond to it in the context of they're engaging in protected activity under a number of laws. And it's a whistleblowing protection. And so you hear them, you thank them for pointing it out. You say you're going to look into that. You're going to explore it. Is there anything else that they would like to share with you about that? And let them tell you everything they want. And then say, is there any suggestion you have about us remedying that? We can't necessarily promise that that will be the remedy, but what are your thoughts? And then you move on to, thank you so much for telling me this. I appreciate it. I'm going to look into this as soon as we get off the phone. But for now, you need to understand that this is not something that would prohibit you from coming to work under the law, and you're still expected to report, and I would like you to do that. And you can come to me as soon as you arrive, and we can talk about the things I've done to address your concerns, but you are going to be required to report, right? So know that if you take any action against an employee on the basis of their complaints of safety, you could run afoul of all of the laws that I've listed there. Safety under OSHA and whistleblowing, and also that's concerted activity that's protected under the National Labor Relations Act, whether you're unionized or not. So one of the things I want you to do then is therefore have the conversation about what's unsafe before you move on to, but you have to come to work, right? So that it's clear that whatever situation is happening has nothing to do with the report of a concern. The other thing you want to make sure you're doing is, just like you would normally do, is do a disparate impact analysis kind of at a routine time of looking at how are we treating everyone, looking at what concessions have been granted, which ones haven't, which ones have been denied, that sort of thing, and figuring out, is there any impact that this is having on one protected class more than the other employee population? Because then you need to reevaluate it and determine if there's something less, something more conservative, less restrictive that you can do to lessen that impact. And we're glad to help with that. Next slide. All right, so let's talk about just some of the laws. FMLA, COVID-19 has been determined to be a serious health condition. And we talked about the situations where, traditional FMLA applies. After the situation is completed, if it involves the employee's serious health condition and they've used all 12 weeks of FMLA leave or 480 hours of intermittent FMLA leave, then you are still required to analyze it under the ADA as we always have. EFMLA, this is only for those subject to the FFCRA, and in that situation, it is only available if the employee has a school closed due to a public order. So that's going to be public order, or if in the jurisdiction that school is only doing virtual work. So you're going to really have to consider FFCRA, EFMLA in those situations. Reminder, that is paid. Unlike the traditional FMLA, this is 10 weeks of paid leave at 2/3 the salary. You can also offer them intermittent if they're teleworking. So let's say you have an employee who's able to remote work, but they need to work 4 hours in the morning and then take the remainder of the day off to deal with young children and the like, or some sort of schedule. Use that as intermittent leave. Have them record that time as intermittent leave. Let them tell you what the schedule is. Set that in the agreement that we talked about, or in the document in the file. But during that time, have them record it as intermittent leave. Pay them under the FFCRA, and then after they have used all the FFCRA leave, if they have any remaining paid leave, you can use PTO for that as well. For times that people are working, you make sure that they're not having PTO credited against them. For times that they are not, if it's the EFMLA, you make sure it's being credited to FMLA, and you make sure that PTO is being used. EPSL, that's also for school, and that was reason number 5, or to care for a child who's ill, reason number 4. So that's, as you remember, 10 days of paid leave. Next slide. So let's talk about the ADA for a little bit. And of course, you are going to get all these slides. We're running through it pretty quickly. But anyone who has a disability that may be impacted by contracting COVID-19 or who is high risk needs to be accommodated. Those are folks who enjoy the protections of the American with Disabilities Act, and therefore you have to approach those types of requests the same way you would any ADA request. So what are they wanting? What are they asking you for? If it's job modification, these are the types of things that you look at. We've given you some ideas here. If they're unable to perform the essential functions of the job with or without an accommodation, then they don't meet the definition of a qualified individual with a disability. But you need to explore that carefully. And if they are unable to perform them, and you're sure of it, and you're sure that it's a clear delineation between the essential functions and the non-essential functions, and you can document that, then you can move on to considering ADA leave as an accommodation. Next slide, please, Brittany. So ADA leave, could you pop back? I think that might be, we might be missing a slide. Sorry about that. When we send out the slides, we'll make sure we include the one with the ADA leave as an accommodation. All right, go ahead, Brittany. Next slide. Let's talk about undue hardship. And again, I'll just mention that we all know what ADA leave for accommodation is. You're going to grant them leave. You're going to grant it for as long as you're able to do so, unless it causes you an undue hardship. And so the first slide, we're going to talk about undue hardship for job modification, and the next we'll talk about ADA leave as an accommodation. So depending on the size of the employer, if you're modifying a job, you evaluate what the cost is. How's that going to impact your bottom line? If you're a larger employer, it shouldn't impact it too much, and therefore you'd want to go ahead and do it. If you're going to pay for an accommodation, make sure you keep the receipts and document the file so that you can show you did so later. What type of business operation do you have? Is it possible to modify a job for them? I'll tell you, I've attended several sessions with Voc Rehab, and they have someone there that comes up with excellent modifications that aren't generally recognized in, the disability community. He creates them for them. So there are a lot of resources out there for you that can help you work with employees. A lot of disabled employees actually really want to work, and so if you help them find a way to do that, that's just a gift to them. Can you modify the job in some way? Can you switch them if you can't modify this job to an additional job and have someone else do this job? Just try to think outside the box here as well. Next slide. So leave of accommodation, you're going to look at things like the length of leave, the frequency of it, and if it's intermittent, how flexible can you be? What is it going to do to coworkers? These types of bullet points that I have underneath impact of coworkers are the things that are considered undue hardship. If you're having your coworkers work extra hours, long hours, and it's starting to tax them, that's not great. That is going to be undue accommodation. If you can have temp employees come in, great, but if it's a technical type position that it's going to take too long to train temp employees, then it's probably not possible. So overtime costs are another one, and how it's going to impact your business operations if it's going to cause you not to meet your deadlines or your contracts. So these are all things directly from the EEOC's website guidance about what is considered undue hardship. And again, any of it must be documented. Not just, yeah, it's going to be an undue hardship, but be able to express the reasons and let it, be fitting into one of these things and an explanation about how it is causing the undue hardship, as well as any documentation that would support it. Next slide. So on to Perry.
Thanks, Chris. I've been trying to answer people's questions in the chat box, but I have mentioned to a few people that I would answer a couple of questions live for the benefit of everyone else and to get Chris's thoughts as well, to weigh in on any of the questions. One question I got was, do we think that the FFCRA may be extended past December 31st? That's really tough to say. I think given that COVID's extended further out than legislators probably anticipated when they passed the law, it wouldn't shock me to see it extended, some kind of 6-month extension to it. But of course that, all depends on Congress coming to some kind of agreement, and they've been, at a standstill on this next round of stimulus. And so, if I was a betting man, I'm not sure I'd bet on Congress agreeing to anything. What do you think, Chris?
Agree.
Next question on the FFCRA is related to what happens if an employee tells you that they have elected to keep their kids at home for a virtual learning option. Would that person qualify for the EFMLA? I think that's kind of the $1 million question that people have been asking. I don't think that scenario is directly contemplated by the law or addressed in the law. And at this point in time, schools are kind of back open. So I don't know that we're going to get any guidance from the Department of Labor on that, although that would have been really nice. I guess my thought on that is if the employee has an option, they can send their kid to in-person learning, but they've elected to be at home. I think you should probably inquire as to why that is. If it has something to do with a medical condition or something like that, all of the things that Chris just talked about with ADA and FMLA and that type of thing, you may need to consider some flexibility with that. But if it's one of these, we just feel comfortable with our kids at home right now, or I'm working remotely and I'd like to have them there with me, then I don't think that alone would qualify for it. What do you think, Chris?
That's true. The ADA protects the employee. It does not give you a black letter law protection if you're unable to come to work, absent what we talked about as far as accommodation and leave. If you're unable to come to work, it does protect you if you're unable, but if you're not unable to come to work because of either your spouse's or your child's vulnerability, the ADA is not the law that kicks in there. The ADA does have an associated disability legal protection, but that's more if you take any action against an employee because, let's say, the cost to the healthcare plan is high because of some condition one of their dependents has. But an employee can't not come to work under the ADA for the someone at home's vulnerabilities. I will say I agree with Perry though. And it is the way I let in on purpose. It's an opportunity for you to offer concessions. I will say, if you're offering concessions for people not to come to work due to someone, a child being vulnerable, you are also opening it up for the same request for a spouse being vulnerable. And so, you don't necessarily have to be consistent if you limit it all to children, but it could in turn it to an indirect sort of ADEA issue, where there's some age issues associated with who gets denied and who gets granted. What do you think, Perry?
Yeah, I think that's exactly right. I think you just got to be very careful with doing that if you're going to make sort of, I mean, flexibility is always, I think, advisable, but you just have to be careful with how you are in your application of flexibility. I think you have to be consistent in your application of your policy to avoid discrimination claims. So I think that's great advice. Okay, Wayne asked, have you come across any quantitative data that determines when it's safe to reopen offices? Something like percentage positive rate is less than X or Y number of positive cases per population. I haven't really seen anything like that, Wayne, at least not from official government agencies. I think that the CDC and OSHA, Department of Labor, and are going to be very hesitant to put anything like that out there. The guidance is much more left up to the determination of the business for the most part. I am sure that there are third-party organizations out there on the internet collecting that type of data. I just haven't seen it yet. Chris, have you seen anything like that okay.
No, I have not. I have not. I can't imagine that anybody would be willing to give an official opinion on something so unknown as that.
Yeah. All right, last one, and then I'll move on. This is an interesting one. This is about remote work. Any suggestions for an employer where most of the employees have to be on site to do their jobs, and management believes that if not everyone can work remotely, then nobody can, other than FFCRA leave. So I guess the position of the company is that, unless we're required to offer you remote work by law, we're not going to do it, since we can't offer it as a benefit company-wide because some people have to be on site. That's an interesting issue, and one that Chris and I talked about on the podcast a little bit yesterday. I think you do have to keep that in. I think you do have to keep in mind how it looks if you allow some employees to work from home and you don't allow others to. I talked at the top about this kind of stratification of lower wage earners from the higher wage earners, and it seems like those that are in exempt positions are given the flexibility to work remotely, but hourly employees are often required to come into the office, and that can, breed a lot of discontent among the workforce. So I think that's a valuable consideration that, and a perfectly reasonable approach probably, that, look, if we're going to treat everybody the same, and if we can't let everybody work remotely, then nobody's going to work remotely. That's going to upset the folks who would otherwise be eligible, but you're going to be upsetting somebody. So I don't know that there's a great solution there. What do you think, Chris?
I guess I'll be the devil's advocate, and what Perry said is right. In other words, this is not an easy thing to answer. I agree with what Perry said. Everything he said is right. And so I can make an additional point if you want to try to use to convince with your owner or, business decider. OSHA, with the social distance recommendations and the OSHA COVID-19 guidance about how to keep your workforce safe, if you look at it from the standpoint of we're keeping the essential workers on the ground safer by sending those that can work remotely home, and opening up more space, less use of common area for those other workers, and couch it in the terms of protecting the existing worker, and do things, on site, that you're appreciative of them, having individually wrapped cookies or those types of things, just sort of things to send them the message that this is to protect you and we're so thankful for you. And I even have some employers who are paying shift premiums or production bonuses for people who are hours worked, but only for the people who are hours worked on site rather than the folks who are teleworking. So just some ideas.
Yeah, I think that's a great point. And, I mean, there is um, you know, there is some thinking that, tough, for the people that have to show up to work and have to be on site that, to do their job. I mean, they knew that when they applied for the job, and if they don't like that, they can, go get a job elsewhere. So I can kind of see that both ways. It's sort of a business decision how you want to do it. I will say, from a legal perspective, you do need to be careful about who you decide to offer it to. Just to, again, make sure you're consistent in your approach and you don't have sort of discrimination complaints because of the way you sort of handpick people to work remotely. All right, we'll jump into the update on COVID-19 litigation. Um, we've got, I think at this point, over 500 lawsuits across the country that are strictly employment lawsuits, not, businesses filing claims over insurance and things like that. These are strictly employees and suing employers because of some COVID-19 related reason. I put 5 to 7 in South Carolina that we know about. That data is really coming from news articles. There's a article in the state newspaper, and then there was an article in the Post and Courier about this. So that's not us scouring the public records to see who's filing lawsuits. I suspect the numbers here are a lot higher than that. Those are just ones that we know about that were featured in press articles. That also doesn't take into account OSHA and Department of Labor and Human Affairs Commission agency complaints, which I'm seeing quite a bit of. I've had 2 clients who've had employees that one was a terminated employee, one was a current employee, just call up the Department of Labor and say, my employer did this. My employer, in one case, the employer denied a request for FFCRA leave because the employee was a part-time worker, hadn't worked long enough hours, that type of thing, and the person called the Department of Labor. The Department of Labor immediately reached out via phone and email to the company to say, hey, this employee has filed a complaint. Here's the relevant regulation. We want to talk to you about this. Another terminated employee for a client did the same thing. So employees are definitely reaching out to the Department of Labor, and that's not reflected in here. Also not reflected in here are just all of the sort of routine, you fire an employee and you get a letter from a lawyer complaining and demanding job reinstatement or demanding money, but they haven't filed a lawsuit yet. And as you all know, that's a very common situation, and we've advised clients who've received letters like that from lawyers. And so some of those numbers for litigation might not jump out at you, but I'll say, and Chris can probably back me up on this, there's a fair amount of employee activity related to COVID-19 with respect to employment decisions. So just keep that in mind when you're making these decisions moving forward. I've had a lot of calls from clients. They've got great documented reasons to terminate somebody, but the person had a positive COVID test and they were out for 14 days, and all of a sudden this is now complicated. What would normally be a routine termination. So just keep that in mind. As far as how the litigation breaks down, as you can imagine, the FFCRA is constituting the majority of that litigation. It's, whether that be a denial of request for leave, or most of them are employee being terminated while out on leave. And I've had a few of these situations with clients where employee calls in on their way, supposed to show up at 8 o'clock for work. They call in at 7:30 and say, "Hey, I just found out somebody I was hanging out with over the weekend has a positive test. I need to quarantine at home and I need to go get tested." They do that. They don't show up to work, for 2 weeks. They don't even communicate. They claim their test results aren't back, so they got to keep waiting, whatever the case may be. An employer gets fed up and with the lack of communication, gets fed up with, potentially being strung along, or an employee abusing the system, and they're fired for it. A lot of those cases are people being terminated while they're out on leave. So keep those in mind. I think, communication is going to be really critical in these FFCRA litigation cases. If you fire somebody, 2 weeks after they took COVID leave, the timing doesn't look great. So, the communications, written communications on requests for leave, relevant updates from doctors on testings and things like that is really going to be your friend in those cases. So keep that in mind. In addition to FFCRA, we are seeing some other types of claims being made. There's a few out there that are retaliatory termination cases. So either the employee claims that they were fired because they raised a safety issue. They were concerned about lack of PPE in the workplace. There was a big case involving McDonald's involving that. That was actually a class action lawsuit, which we're seeing a lot more of, which are, very concerning, because those are very expensive for the employer to defend and to resolve amicably. Discrimination complaints, wage and hour complaints related to reduction in compensation, complaints from employees about violating Section 7 of the NLRA, which, provides that employees in certain instances have a right to complain about the terms and conditions of their employment. So that kind of intersects with the safety issues. And so a lot of those safety terminations assert claims for Section 7 of the NLRA. Some of you may have seen the article in the Post and Courier recently on this. It's called "Laid Off or Fired While Quarantining for Coronavirus. These Workers Sued." This is one of the articles. I've got a link in the slides where we pulled some of the statistics from. Not a whole lot in the article specifically to mention. They didn't really dig into the facts of the case, other than, again, it was a similar fact pattern that I described earlier about somebody being terminated for, quote unquote, attendance problems, and the employee claiming that, no, I was just out on COVID leave. That's not an attendance problem if I'm out for COVID leave. And so it's a he said, she said. We don't, reading about these things in the newspaper, you just don't have all the facts, and so it's tough to say. But it's a good reminder to be careful in those situations. I think the other important thing about to note about this is that employees definitely seem to be on high alert about these issues. Some of them are, let's say, taking advantage of some of this, but they also, many of them realize that, well, they think this is a shield from being terminated. And so if they're terminated, they think they can just claim it was related to COVID and, scare the employer into paying them severance money. So the fact that this appears in the news all the time is really just emboldening some employees. And so just keep that in mind. I'll go through these quickly because I know we're reaching the end here. A couple of other points. Remember workers' compensation and OSHA. If you have employees that, are out due to an outbreak in the workplace. I had at least one client file a workers' comp claim on behalf of an employee. The insurance company denied it based on the fact that the employee didn't get COVID at work, which we all kind of anticipated the insurance companies may do. So that's going to be interesting to see if the state actually passes any legislation on that, which some states have done, and I think has been batted around a little bit in the federal stimulus. But keep that in mind. If you've got employees that are out and it's potentially traceable to the workplace, keep in mind, and we've talked about this in other presentations, keep in mind filing the workers' comp claim and logging that on the OSHA log. And it should be an employee's only remedy against an employer for getting it in the workplace. So just an update on legislation. I'm getting questions about the unemployment. As many of you know, the $600 a week additional unemployment benefit that employees were receiving expired at the end of July. Congress has not taken action. The Democrats in Congress wanted to extend that. Republicans in Congress did not want to extend it or wanted to reduce it. Trump signed an executive order partially extending it. I don't think anyone can quite figure out when or how that's going into effect and what legal challenges they're going to be to that. But I will say that hopefully what concerned a lot of employers was that employees would be receiving more money while out on leave than they would while working. And I think we're probably past that, hopefully, at this point. South Carolina, unfortunately, and kind of surprisingly, is one of the only states in the Southeast that has not passed liability protection. The South Carolina Chamber of Commerce is just working in overdrive to try to get something accomplished. They are hoping that when the General Assembly reconvenes in September, they are going to pass something immediately in September. I think there's a lot of pressure on them to do that and a lot of incentive to do that. Basically, what those laws that are passed in other states say is that employers cannot be sued for outbreaks in the workplace if they follow safety guidelines. And so that's back to the importance that we've talked about on some of these presentations about having a written safety protocol and following OSHA and CDC guidance. Those laws also say that workers' comp is the exclusive remedy to try to protect employers from lawsuits. Continued discussions on a massive relief bill in the U.S. Congress, but I think we're probably as far apart as we ever were in getting some kind of additional federal legislation at this point in time. All right, one last thing that I probably just am going to mention given the time that we have. The General Assembly did act on one thing non-COVID related during its last term, and that was the Lactation Support Act. We wrote a blog post on this that breaks it down on scemployersblog.com. So I would encourage you to check that out. But basically, South Carolina in recent years has gotten surprisingly aggressive in passing employment legislation related to working mothers. And this is another example of that. It provides accommodations and protection from discrimination to working mothers who choose to express breast milk in the workplace, and importantly requires reasonable steps to provide them with a space in the workplace to do that, absent an undue hardship, which I can't imagine what the undue hardship would be. So keep that on your radar. That's something that you probably want to amend your handbook and policies in the workplace to reflect this change. Apparently, the Human Affairs Commission may be coming out with updated posters and notices related to that. I haven't seen that yet. I went on the Human Affairs Commission website yesterday and didn't see anything related to that. If you have seen anything, please drop us a comment in the Q&A box. That would be helpful, but I haven't seen anything on it yet. The last slide is just a couple of final pointers on best practices to avoid liability. I think I've included this slide on every presentation that we've done on COVID. I mean, it's just kind of a, good thing to keep in mind, all of this. Think carefully before terminating employees right now, given how tense everything is. Create a written safety plan if you have not already. Very carefully consider all requests for leave. Reach out to legal counsel if you're unsure about a request for leave and whether an employee gets paid and all of that kind of stuff. But err on the side, I think, of providing the benefit of the doubt to the worker as long as they're not abusing it. And then negligence law, which is failure to act reasonable under the circumstances, always a good idea to keep in mind. Chris, do we have any questions that we need to address? I know we're right at an hour. You're on mute.
Sorry, I was typing answers and I didn't want you to hear my keyboard. I've had some interesting ones, and I'll just run down them right fast. So somebody asked, what do we do if an employee can work 4 days a week but needs 1 day off? You would evaluate why that is. They'd have to provide you with the FFCRA information, but that would be protected. And if they've used up all their FFCRA, then they can use their other paid leave. If it is a situation that deals with, that's the kids, the child's going to school, which that's happening a lot, 4 days a week and 1 day they're home, then that's something that you ought to consider, even if the FFCRA leave and your other paid leave has been extended or already used. And then you would give them some sort of unpaid leave. That's a viable request if it's on the basis of the school issues we've talked about. Another question that we got is, if I have a teleworking employee and they say they're going to need to take intermittent FMLA leave, do I have to grant it? Well, they're entitled to FFCRA EFMLA leave. And therefore, just because they're working intermittently, just because they're working remotely doesn't mean they're not entitled to the same benefits, the same legal benefits that they would be if they were working at their desk. So in that situation, you just work out an intermittent agreement with them. That was a scenario I was giving you earlier where you have someone who can work half of the day, 4 hours in the morning, but they need to take the rest of the time. That can be intermittent FMLA leave, or you can work an accommodation with them where they're doing the rest of their work in later hours. So those are the types of concessions that you're required to engage in under intermittent EFMLA leave, as well as just generally flexibility. So Perry, would you have anything that you would want to add to that?
No, I don't think so. The only thing I wanted to add to my comments earlier was that on the liability protection issue, I'm not exactly sure at this time what the chances are of it passing, but I mentioned that the Chamber of Commerce is working hard on that. I know the South Carolina Manufacturers Alliance, which I did not mention, is also at the forefront of that. Probably worth, reaching out to your representatives on that, or reaching out to someone at the Manufacturers Alliance or Chamber of Commerce to try to get that passed, because I do think it's important.
I agree with that, Perry. All right. Looks like we have all of the questions answered. Is there anything else that you would like to add, Perry?
No, thanks everybody for joining us today. As always, let us, don't hesitate to reach out to us if you've got questions or feedback.
That's right. And just keep up with our blog. Look for any of our announcements so that we can keep you updated on everything that's going on, and also include you in our seminars. Thanks for attending. As always, we appreciate your support.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.